Hello everyone. Let us do the newspaper analysis from the perspective of the exam. And today I feel there is nothing very substantial in the Indian Express, but in Hindu, this explained section is maybe relevant. But we have already discussed the new education policy, and I have not found anything new. So the main story in Indian Express as well as in Hindu has been on the contempt of court. Fine. So in this FAQ section, there are some facts about the contempt of court proceedings. Let us see what are the important facts. I don't think we need to go through that education and environment impact assessment policy again, but if you want, you can store these two articles. Fine. So the subject of contempt of court. What is the rationale for this provision, and do the judicial institutions need protection? The story so far: the contempt of court as a concept. So first paragraph tells about the purpose of contempt of court. You can underline as a concept that seeks to protect the judicial institutions from motivated attacks and unwarranted criticism, and as a legal mechanism to punish those who lower its authority. This follows the initiation of contempt proceeding against Prashant Bhushan. So all of you know that the proceedings for criminal contempt has been initiated suo motu by the court against the social activist and the lawyer Prashant Bhushan. Now this is not the first time court has initiated this proceeding. Initially also, earlier also, another high profile case has been against the famous author Arundhati Roy. Fine. So this thing has been there in news frequently. How did the concept of contempt has come into existence? So this concept of contempt has been a part of the common law, and because once the kings used to have absolute power and kings used to be the fountain of justice, so it was provided in context of the king, and it is actually asserting the authority of the kings. Now, what is the statutory basis for the contempt of court? So the two article 129 and article 215 is the basis. Both of these two articles tell Supreme Court and High Court as a court of record, and because of them, that they are court of record, they have a power to punish for their contempt. What are the kinds of contempts? So in contempt of court, there is a Contempt of Court Act 1971, which was amended in 2006. This Contempt of Court Act it mentions civil contempt. Civil contempt means willfully disobeying the order of the court, and the second is a criminal contempt where scandalizing the court, prejudice or interference or obstruction in the administration of justice. Next, here the rationale for this provision is courts must be protected at the punishment for contempt of court is simple imprisonment for up to 6 months and a fine up to 2000 rupees. What is not a contempt? Fair and accurate reporting will not amount to the contempt. Is truth a defense against a contempt? You are speaking something which is a truth. Is it a defense against a contempt? So till 2006, truth was not defense. In 2006, an amendment was made by which truth has been made defense subject to the condition that it is revealed in the public interest. To introduce truth as a valid defense if it is in the public interest and invoked in a bona fide manner. Okay. So now, because there are not many articles and we have already done the articles on education policy and environment impact assessment, I think I will give you some brief notes on this entire issue of contempt of court. Okay. Just for holistic understanding, understand the entire issue of the contempt of court. So it is a part of your polity syllabus, but because it is very controversial, I don't think they will ask question on that. But still, because newspapers are flooded with this issue, I want to give you some information beyond what is coming in the newspaper. Fine. So, the contempt of court, and in which angle you should see this particular issue from the perspective of exam. Okay. So, from the perspective of exam, there can be an opinion based question. And the question can be something on the compatibility between the power of compatibility between the contempt of court and democratic governance, or the relationship between fundamental right, freedom of speech and expression, and whether contempt of court can be considered as a reasonable restriction or not. And here I will tell you some facts, some global trends, and some important judgment, and some quotes which you can use here or elsewhere. Fine. So if we take the recent issue or in the past, as I've told, like Prashant Bhushan, the lawyer and a legal activist, he had made certain tweets, and for that the court has taken suo moto, means on its own. In Hindi it is called swatah sangyan. ठीक है? That his action amounts to the contempt of court. Means contempt means avmanana or undermining the dignity of judiciary. Fine. So in this case comes the tussle between the contempt of court and the freedom of speech and expression. Okay? So we can understand that democracy cannot function without freedom of speech and expression. And that is the fundamental difference between the democracy and authoritarianism or totalitarian form of government. So the most important thing in democracy is the right to dissent and the freedom of speech and expression. So whenever any article or whenever any question or essay comes on freedom of speech and expression, you can start any of these questions or essays through the views of three important scholars which are normally quoted. One is J.S. Mill, second is Milton, and the third is Voltaire. And all the three thinkers I have taken from the various judgments of Supreme Court with respect to the contempt of court. Fine. So J.S. Mill says that no point suppressing the truth. Because truth automatically comes out. And J.S. Mill has given one famous harm principle also. Fine. Recognizing that the unrestricted freedom will turn into a license. Fine. Now next, you can always write about Milton's famous work A Rio Pactica, which is always referred whenever you write essays, whenever you write judgments. Actually, I have found that reading the judgments by the Supreme Court provide a very good material to write essays also. Fine. So this is the quote. You can note it down if you want. And the quote is saying, truth is strong, next to Almighty. And the truth is so strong that I am writing here, it needs no police. I am writing here, no stratagem, no license to make it victor. Means truth will always win. Now what message I want to give, like whenever you study any topic, you should think in a way that where all I can use this topic and go for a holistic understanding of a particular topic. Fine. So you can find all these things on the net, and all of you must be quite aware of the Voltaire's statement on freedom of speech and expression, that I do not agree with what you say, but I will defend your right to say so. So my purpose is, you can take the exact words from the net and note it down, keep it ready with yourself. They can be used at multiple places. Okay. Now we have discussed that freedom of speech and expression is the most valuable of all freedoms, but we will also have to define that freedom without restrictions become license, and freedom and becomes license, and hence there is a need to balance between the exercise of freedom by the people and the rights of the society and the nation, or the rights of the other. Fine. And then you should come directly to the provision of freedom of speech and expression in Article 19. And you can say that the first freedom granted in Indian Constitution is freedom of speech and expression, which also includes the freedom of press. However, Constitution provides for the reasonable restrictions and contempt of court is one of the ground to introduce the reasonable restriction. Okay. Now, what are the constitutional provisions what is our rationale behind the contempt of court as such. Fine. So what you can say, next thing is you must understand the rationale behind it. Rationale behind introducing this provision that freedom can be restricted in the interest of the justice, or if I say anything or I do anything which goes against the administration of justice or the dignity of the court. Fine. So reasonable restrictions can be applied. Fine. So under the Constitution, Parliament, Union Parliament has power to bring law with respect to the contempt of court. Means what will be treated as a contempt, and if contempt happens, then what type of liabilities will be there on the person. Okay. So in 1971, Parliament has brought a law on contempt of court. Fine. So it doesn't define as such what all will happen under the contempt. It doesn't define contempt, but the section 2 mentions that contempt will be of two types: civil and criminal contempt. Fine. Then section 2A tells about civil contempt, and civil contempt is willful disobedience to the order, decree issued by the Supreme Court, because Supreme Court has issued the order. So there are two parties in the conflict, and Supreme Court has issued the order, but other party does not implement it, execute it, or act according to it. Means the judgment of Supreme Court carries no value. So this will undermine the faith of the people in the administration of justice. And if the faith of people in the administration of justice goes, then what happens? Might becomes right. Then what will happen? Once the faith will go, if the faith in justice goes, then what happens? Then might becomes right. Might becomes right in Hindi text, in Indian text, Matsya Nyay will prevail. Matsya Nyay is what? Big fish eating the small fish. Fine. Matsya Nyaya. And if this happens, the entire edifice of the society will collapse. In Indian text, if we see Manusmriti, it says that it will result into arajakta, anarchy, statelessness, and disorder. In political science, scholars like Hobbes described the state of nature, and he says that the life of man in the state of nature will be nasty, poor, brutish, and short. So, this is how we understand the importance of the fact that the judiciary's decisions have to be implemented. And who has to ensure the implementation? Obviously, the government. And our constitution provides certain set of articles to give substance to this power. So I will come to that. Fine. Now the next thing is the criminal contempt. Criminal contempt means scandalizing the authority of the court. Any actions which appears to be prejudiced against the court. And third, interference or obstruction in the path of justice. Okay, so this has been defined as the criminal contempt, and here the court's ordinary process is courts can take suo motu action or the Attorney General or Advocate General can bring the notice, because it is the responsibility of an executive or any aggrieved person. Fine. And the punishment as mentioned in this article was, the punishment in case of contempt can be simple imprisonment up to 6 months or fine of rupees 2000. This is the maximum punishment, or both. Fine. However, the same act, 1971 Act, also suggests that if a person asks that his act has to be condoned, and if judiciary thinks so, he can be condoned. So the normal process is not to punish, only to condone or to admonish. Fine. Now this is the provision in the law, and it was founded that the contempt powers are very discretionary powers, and hence in 2006 an amendment has been made in the law, and where it said that contempt, as any action is a contempt of court, this will be decided only when, I will tell you the words. only when it is a substantial interference in the administration of justice. So only when there is a substantial interference in the administration of justice. The contempt of court can be seen something similar to the sedition. So in case of sedition, Supreme Court itself has given a judgment in Keshav Singh case. I may not be quoting the right case, but you can check the case, and there it said that just because someone tells something defamatory against the state itself does not result into the sedition until and unless it provokes somebody to do something. Similarly, keeping that, because there is a parallel between the contempt of court and the sedition against the state. Fine. So keeping that judgment of Supreme Court, this change has been made, and you can see in that explained section it is also mentioned that only when substantial interference happens in the administration of justice, and it has been held that in the same amendment that truth will be treated as a defense. Fine. If whatever you have written is truth, then you will not be subjected to the contempt of court. But there is a rider here. Rider means there is a limitation here, and the rider here is it has to be, matlab truth you cannot reveal until unless you can prove that you have revealed some truth in the interest of the justice. Okay. Now, let us see the constitutional provisions. So, under Article 129, under Article 215, here Supreme Court and here High Court, they both are the court of records, and the court of records have their inherent jurisdiction, and as a part of their inherent jurisdiction they also have power to punish for their contempt. Fine. And besides this, Supreme Court has also used the powers under Article 142. It has power to pass any order in context of any case pending before it for the purpose of doing complete justice. And then there are certain other articles. For example, Article 144 in the Constitution, which says that all civil and judicial authorities will act in aid of Supreme Court. Article 141, which says that the law declared by Supreme Court will be binding on all courts. Then Article 261, which says that full faith and credit will be given to the judgments throughout the territory of India. You can see these articles in the Bare Act and you can understand. Now, from the prelims point of view, under this Contempt of Court Act, High Court has been given power to exercise this power in context of contempt of subordinate judiciary. Fine. So this is some institutional aspects. Now let us see what is controversial. What is controversial? Fine. The controversial is that these are not my views. Fine. I am just telling you the facts. Don't think I am against it or I am for it. Fine. So the controversial view is that the manner it has been exercised in India has at times gone against the spirit. Means the very purpose for which this power has been provided. So at times to stifle the freedom of press. Second, at times to protect the erring judges. And it has been held that the manner in which it is used has a chilling effect on freedom of speech and expression. Fine. Now, fine. So now let us see the history of this power of contempt of court. What is the history behind it? Second, what is a global trend? Fine. So history is, it has its origin in the tradition of the common law, and it belonged to the time when kings used to have absolute powers. King used to consider as a fountain of justice. Means it has origin not in democracy rather than in autocracies. Fine. And as democracies have arrived, in the mature democracies like Britain and US, it has become redundant. Fine. So in 2012, the Law Commission in Britain proposed to abolish it and consequently the British House of Commons had brought a law and abolished it. Fine. Similarly, in US also, because of the different judgments of Supreme Court, it has been vanished or nobody is punished for the purpose. Fine. Same is the situation in Canada, used very rarely, only when it appears that there is a distinct threat to the dignity of the court, something the type of amendment that we have made in 2006. So the global trend is, it is considered as the relic of the past, and now we are giving greater importance to the freedom of speech and expression. And in one context, it is said that in the present age, when the world has become flat because of the social media, and every fraction of the second people are expressing their opinion, judges should not be so much worried about, and they should maintain their temper, because the position of the judiciary is very different from the other two branches of the government, and in comparison to other two branches of the government, judges are supposed to be more literate, more educated, and hence there has to be a difference in the way they conduct and the other two branches of the government they conduct themselves. Now, in this entire case, whenever a question comes, it is worthwhile that you mention the views of Justice Krishna Iyer and the famous case Mulgaonkar case. And in this case, Supreme Court has given certain guidelines. There are 6 guidelines which judiciary should follow. So these are the guidelines which judiciary has framed for itself, and hence it is expected that judiciary should follow those guidelines. Fine. And you have to know that obstruction in the administration of justice is different from the protection of judges. And at times a confusion comes when protection of judges is seen as an obstruction of justice. There is a separate law in India with respect to the protection of judges. This was brought in 1985. So this is just for the information. Now, you can see any good article will always refer to Justice Krishna Iyer's view in that famous case Mulgaonkar case, where Supreme Court has given the 6 guidelines. Fine. And I think that you must know the beautiful views expressed by Justice Krishna Iyer in Mulgaonkar, M-U-L, Mulgaonkar case of 1978. So first point of his view is law of contempt has vague and wandering jurisdiction vague and wandering jurisdiction and uncertain boundaries. Fine. So this is vague, wandering jurisdiction and uncertain boundaries. In this context, we can also link it with the case on section 66, I believe. Ignore it, I'll tell you. Fine. So now in this Mulgaonkar case, judiciary has given the 6 guidelines which are important. First is court will act with severity where justice is jeopardized. If it appears that justice, not the judge. Fine. So if it appears that the justice is seriously jeopardized, then court should act. Second thing, there should be a balance between freedom of speech and expression and the dignity of the judges. Fine. And it says that the free people are guarantors of freedom of speech and expression. Next, it says that we should avoid confusion between protection of the libelled judge and administration of justice. If something serious, court must act. There has to be a balance between the two, and we should segregate two things, that is it something against the judge or is it against the justice. Next, it talks about the need to recognize the role of press. Next is an important point. Judges should not be hypersensitive. And whenever you take decision, take the totality of the factors, and in case you think there that the intention is wrong, then you should strike at the root. Okay. So a person talking about the contempt of court issue should have awareness about the Mulgaonkar case. Fine. And if we see the debates, if we see in USA, one of the founding fathers of USA, Alexander Hamilton, he has held that out of the 3 branches, judiciary is the weakest because it neither has police nor purse. Hence, it should have power to ensure the compliance of its judgment, and that is the basis for the contempt of court powers. Fine. Next, if you talk about the Constituent Assembly, in Constituent Assembly, T.T. Krishnamachari was the person because of which contempt of court as a reasonable restriction on fundamental rights has been introduced in Article 19, and the members like Pandit Thakur Das Bhargav, they believed that there is a possibility of misuse because who will judge the judges? Fine. So in the end, whatever, in the end, you can always say that the issue is we have to arrive at a fine balance between the power of court as well as the power of the people, and the power of judiciary is not for its own self. The contempt of court is not for itself. It is for ensuring the rule of law. Somehow in the countries, the balance is tilted in favor of the freedom of speech and expression. And in these type of topics, you can note down one important quote by Atkins. I really love this quote, and it can be used at multiple places. The quote is, "Justice is not a cloistered virtue. She must be allowed to suffer the scrutiny and should be respectful even to the outspoken comments of ordinary persons." So justice is not that nobody can touch it. It is not a cloistered virtue. Very, very important statement. It is not sanctum sanctorum which cannot be touched. So you can, whenever the question comes, you can end your answer in this context, and you can also mention the view of American Supreme Court in one case, Bridges versus California case. Where it has said that if court will forcibly impose the obedience, it will give rise to more resentment. So I hope this discussion has given you a holistic understanding and may help you in future making the opinions and reading the articles. Fine. So this was the story so far So whenever you study holistically, and you can take care of these points. Sorry. So we have finished this topic. Now, this much I think this is a factual topic. You can do. Some other day we will discuss about the powers of governor, and here who summons an assembly under Article 174. Governor summons, but he has to act on the advice of the chief minister, and this was given by court in Nabam, Rabia, Arunachal Pradesh case. Fine. So I think rest you can easily from today's paper. Only this was, but this FAQ section is already easy enough. I hope you like the discussion and it helps you in your preparation. So let us meet tomorrow. Good night to all of you.